complaints. Question. Mr. Mollison told you at that point in time that if there were any other issues with them, that you should contact him immediately. Isn't that right? Here's the answer. He said, I think he said to make sure Ryan Poley knows about it, and then I'm not sure exactly how it went, but I am quite sure that I know we talked, and he said come to him, but I understood that I would go to Ryan first still.
Selective memory? Is this what we call it?
Did the attorney forget to prep his client before he testified?
So
clearly not a Mark Furman client.
My client's testimony is, well, I fortunately I only represent saints, so I've had that good fortune for 34 years. But so the court...
And articulate saints.
Articulate saints, very bright, reasonable, fair, articulate saints. So the question is, based upon that evidence, could a jury find that Mollison had delegated to Poley the right to receive harassment complaints, which meant the obligation to transmit the complaint up the corporate ladder? And if the answer was Mollison had delegated Poley, then the employer would be liable. But the First Circuit Court of Appeals agreed with the district judge that that testimony I just read to you wasn't enough. That what Mollison was saying, if this happens again, you report it to me. And that the subjective belief by Poley, by the plaintiff, that Poley was a supervisor who could receive complaints wasn't enough, so Mr. Wilson lost.
Wow, a win for the